That is scary. This is a Larry Austin case. It was where there were secret text messages where they ended up making a decision to fire their mayor in Mansfield, Arkansas, and Mayor Austin came to us. This was pre-Wade. We're going to be talking about pre-Wade decision. Before Wade, it was pretty clear, that they admit that there was group text messages were sent between council members in violation of FOIA, and this constituted an illegal meeting, which were not public and which there was no notice given. We heard about notice requirements, the media required notice of these meetings, and they were enjoined from conducting future businesses through these text messages. This was a strong order, but you're going to see what's changed after the Wade decision. And this is Bruce Wade versus the City of Fort Smith. Again, this case went all the way to the Supreme Court, and they referred to the McCutcheon case we just talked about, and they say that this was secret emails, trying to fire trying to do away with the Civil Service Commission. Again, a highly contentious issue. Rather, like the communication in McCutcheon, the emails here contain information, a recommendation, and unsolicited responses with no decision. So basically the Supreme Court is saying, hey, the city administrator didn't ask for a decision, so there's no meeting. There was no decision made. That's what the majority held. So in essence, there's much confusion, because if you read this opinion literally, because there was a strong dissent in this, dissenting opinions by Justice Hart, dissenting opinion, very strong in terms of opinion. It says, perhaps unwittingly, the majority has imposed a requirement that to be a meeting, an email must directly solicit a response. So somebody in that meeting's got to say, how do you vote? You got to, the 7 that are there, they have to render a decision, not just discuss business, and involves more than 3/7 of the board of directors. Because in this case that we took all the way to the Supreme Court, 3 out of the 7 made a decision. They were discussing. They were in agreement that they were going to do away with our Civil Service Commission, and you and I had no knowledge of that. And then Justice Hart says, still yet, these determinations will almost certainly require a lawsuit to resolve. And she's exactly right, and or legislative action. And that's the reason that Robert Steinbuck, who wrote the FOIA book, and I brought before the legislature this last time a bill which would clarify this law. It never got out of committee. We testified on it. It never even got a whiff to get out of committee. Let's see. This is another dissenting opinion. This is Justice Hart going on, and she said, in the case before us, the email group was established to discuss public business, which the directors obviously did. By the way, I just had another FOIA case, got a judgment against the City of Fort Smith by this same email chain where they're sending out emails, still discussing business, and they refused to give me the email chain, so we had to sue them. But today's majority opinion denies the electorate of Fort Smith insight into the performance of its elected officials and allows those public officials to make their decisions in secret. See, this is a Supreme Court justice. Secrecy is poison to democracy. On that point, I respectfully dissent. She sees the problem. This is Justice Wynn in the Wade case. The discussion by the board members in the non-public forum makes this case clearly distinguishable from McCutcheon. The fact that the responses by certain board members were not solicited by a city administrator is immaterial. So the Supreme Court in Wade says, well, unless the administrator is saying, how are you going to vote, it's no meeting. But if they just get in there, I mean, they could just as well, if you apply this to in-person meetings, the same concept, they could go down, 7 of them could go down to the local McDonald's, get in the back room, 3 of them have the discussion, come to a conclusion that this is what they're going to do, and the rest of them sit there and don't say anything, and that is legal under the Wade decision. Does anybody see that that's a problem? I mean, if they're doing it on an email chain, the Supreme Court says it may not, it's not a meeting.